To tell us more about Rex Education and to officially open today's event, let us hear from Rex Education's Chief Marketing Officer, Ms. Jean-Marie Tordesillas.
Good afternoon, everyone. With 70 years of service and dedication to education, Rex now evolves from that iconic bookstore that we all know to something bigger and more significant. We are now Rex Education, a brand, a community, an advocacy, a tradition of service dedicated to inspiring every Filipino lifelong learner to advance themselves and uplift others. We have gone from just providing learners with published materials to accompanying them through their lifelong learning journey. Learning in all forms, beyond the walls of institutions, learning for delight, enlightenment, and fulfillment. True to its tradition of service, Rex Education is guided by the Educampion philosophy, which seeks to rally and empower education duty bearers. An Educampion is a champion for education who works with the best interest of the Filipino whole learner in heart and in mind. Under this philosophy, Rex Education seeks, among others, to empower duty bearers in the field of education to champion education no matter what the circumstances are. It is through and because of this that we are excited to spend the next 2 hours with you as we come together to unveil our most updated offerings for the Philippine legal community, especially for our local government. Understanding the Katarungang Pambarangay law, notes and cases, and understanding the Sangguniang Kabataan reform law, notes and cases, which were written in a concise and easy-to-read manner that provides a complete guidance for our Sangguniang Kabataan and barangay officials. The author believes that these laws are key innovations that will have a positive impact in the grassroots administration of justice. These books are expected to open a window for the readers to perceive and grasp the intention of the framers of the law and guide them in its application. I have the honor to present the honorable man behind the book. He is the managing partner at Valera Burns Montero Tria and Partners Law Offices, legal consultant of Kabarangay, the chairman of Philippine Association of Fintech Lawyers, and a law professor of the University of Asia and the Pacific Institute of Law, Emilio Aguinaldo College School of Law and Justice, and the University of Makati School of Law. Friends, join me in welcoming our partner in championing legal education, Attorney Aristotle Valera.
Yeah. Magandang hapon. Am I loud and clear?
Yes, Attorney.
Yes. So the selling point actually of these two books is that I tried to explain and discuss contentious issues, those in the gray areas. So compared to the other books of some authors, these two books will try to discuss those problems which is in contention. So what I prepared today is basically not contained in the books that I wrote. Maybe my primary reason is for you to buy the book and read it for yourselves. Kasi pag diniscuss ko na yung contents ng libro, di na kayo bibili. So, what I will discuss today are some contentious issues with regards to the SK reform law as well as the revised Katarungang Barangay law. So, unahin natin yung SK reform law. One of the contentious issues with regards to barangay officials, especially now na lalapit na yung election, is that our barangay officials, including the SK, allowed to engage in partisan politics. Okay? Those who says that they should not often cite Section 38 of the Omnibus Election Code. So let us read Section 38 of the Omnibus Election Code. It says, conduct of elections. The barangay elections shall be non-partisan and shall be conducted in an expeditious and inexpensive manner. No person who files a certificate of candidacy represent or allow himself to be represented as a candidate of any political party or any other organization. And no political party, political group, political committee, civic, religious, professional, or other organization or organized group of whatever nature shall intervene in his nomination. Now, if you will read this Section 38, it is clear that it is the barangay election who shall not be non-partisan, hindi yung barangay officials. Okay? So, the provision merely states that the prohibition applies only at the time of the filing of the certificate of candidacy of that particular barangay official. Okay? And is silent whether or not pagkatapos ng ma-elect yung barangay official, pwede na nga siyang maging miyembro ng isang partido politikal. Actually, this was contained in DILG Opinion number 17, series of 2007, dated February 14, 2007. Now, dun naman sa nagsasabi na pwede. Okay. Because if you will define political activity as defined in Book 5, Title 1A, Chapter 8, Section 55 of the Administrative Code of 1987, it specifically excluded expression of views on current political problem and issues, or the mere mentioning of names of particular candidates whom this particular barangay official, including SK, supports. Now, in Section 261, Paragraph 1 of the Omnibus Election Code, it specifically states, any officer or employee in the civil service, except those holding political offices, okay, except those holding political offices, can engage, intervene in any election campaign or engage in any partisan political activity. So dun sa nagsasabi na pwede, sabi nila, hindi. Sinasabi dito sa Section 261, any person who is holding political offices, and it does not distinguish whether these political offices are barangay officials, local officials, national officials, etc. Okay, so what is my take on the matter? If you will read the case of Quinto versus Comelec, wherein the Supreme Court said that it is from the very nature of elective officials holding political offices to take sides in any elections, because precisely that's the very nature of their office, partisanship and political activity. However, let us look at the Comelec resolution number 1, which was issued in 2016. The Comelec and the Civil Service Commission issued ang memorandum circular. Sinasabi dito sa COMELEC, sa Civil Service Joint Circular, na hindi pwedeng mangampanya ang mga barangay officials. Okay? Ang excluded lang daw dun sa term na political offices are the President and Vice President, the members of the cabinet, other elective officials except barangay officials. Okay? Personal and confidential staff of the above-mentioned officials and members of the reserve corps of the area. Why? Diba? When we were taught in law school that when the law does not distinguish, you should not distinguish. So what is there? Is there a substantial distinction between the positions, other elected public officials and barangay officials? Is there a substantive distinction? Sa tingin ko, wala. So on my take, pwede na mangampanya ang mga barangay officials and SK officials because technically there is no law prohibiting them. Take note that this COMELEC and CSC joint resolution is a mere administrative issuance. It's a mere administrative issuance. Now, let us go now to the SK reform law. So, Republic Act 10742, this, in its short title, is known as the Sangguniang Kabataan Reform Law of 2015. It consists of 37 provisions. Under its repealing clause, it's specifically provided that Section 329, Sections 423 to 439 of the Republic Act 7160 or the Local Government Code is repealed. Okay? Section 10, Paragraph O of Republic Act 8044, otherwise known as the Youth in Nation Building Act, is also repealed. Section 1 and 2 of Republic Act 9340, entitled An Act Amending Republic Act Number 9164, resetting the Barangay and Sangguniang Kabataan elections and for other purposes, is also been repealed. And there is catch-all phrase in the last paragraph states that all other presidential decrees, executive orders, letters of instructions, rules and regulations, or portion thereof are also deemed repealed if it's inconsistent with the said law. Now, Section 329, which was repealed, refers to the disbursement of barangay funds, while Section 423 to 439 is the old provisions governing SK, okay, which was replaced by the provisions of the SK reform law. Section 10, Paragraph O of 8044 refers to the mandate of the National Secretariat of the National SK Federation to provide training. This is now the function of the Local Youth Development Office as provided under Section 26, Paragraph D4 of the IRR of the RA 10740. Okay. Qualifications for membership in the KK. KK means Katipunan ng Kabataan, SK officials. So, first qualification with regards to membership in the KK is that a person should be a citizen of the Philippines. Remember, citizen of the Philippines, not natural-born citizen of the Philippines. So, meaning, those who are naturalized can be registered member of the KK and can run as SK official. Now, doon sa pangalawang qualification, must be a registered member of the KK. Okay. Now, kung titignan ninyo na yung registration in the old law, nakalagay doon, in the list of the SK, or in the official list in the custody of the barangay secretary. Okay. So in the list of the SK, this is problematic under the old law because while Section 424 mentioned okay.
Hang po kayo kanina. Okay po. Okay na daw.
Okay. So doon sa duty ng barangay secretary to list down members of the residents in the barangay, mayroong particular provision. Actually, there was an old law under Presidential Decree 431 dated April 8, 1974. Section 1 states that permanent list of barangay members. There shall be a permanent list of barangay members in every barangay consisting of all the registered members thereof. Mamaya dun sa Katarungang Pambarangay law, mag-discuss din natin itong particular provision na ito. Under Section 394D of the Local Government Code, it specifically provided that one of the duties and functions of the barangay secretary is to keep an updated record of all inhabitants of the barangay. Okay. But gaya ng sinabi ko, with regards to the first instance, in the list of the SK, wala namang ganun. So that's why in Republic Act 10742, pinalitan na nila. Nakalagay na in the list of the COMELEC on or the records of the SK Secretary. Ngayon, binigyan na nila ng specific provision para yung SK Secretary mandated na siya to keep all the records of the Katipunan ng Kabataan. This is now expressed in Section 14. So, nakalagay na. Section 14, Paragraph A. Keep all the records of the Katipunan ng Kabataan, including the list of its qualified members. So, meron na. So, how about, bakit in the list of the COMELEC and or the records of the SK Secretary? Now, one of the innovation of the SK reform law is that this is only the instance wherein a particular voter has the right to vote, but he or she cannot be voted upon. Okay. Bakit? Balik tayo kanina doon sa ating yan. Okay. Kasi ang membership sa Katipunan ng Kabataan, at least 15 years but not more than 30 years of age. But kung tatakbo ka o magiging appointed official ka ng SK, ang age requirement is that you must be 18 years of age but not more than 24 years old on the day of the elections. Okay, on the day of the elections. Now, bakit magkaiba yung age bracket? Okay. Kasi ang nagiging problema noon in the old SK law, yung mga SK officials who are minors cannot enter into contracts kasi minor de edad pa sila. Hindi lang yan. Pangalawa, hindi sila mafailan ng kaso. Lalo na pag nagkaroon ng pagwaldas ng mga ng pondo ng gobyerno, di ba? Hindi sila makasuhan kasi minor de edad sila. Okay. So, ang ginawa ngayon dito sa bagong batas, dapat yung elective and appointive SK official, dapat hindi na minor de edad. Okay. Dapat at least 18 years of age, but not more than 24 years old. Now, bakit hanggang 24 years old lang? Samantalang dito, membership is up to 30 years of age. Kasi naman, pag binoto mo, 30 years old na, ang term ng SK is 3 years, di ba? So, the next year, overage na siya. So, that's why, ang qualification dapat is that 18 but not more than 24 years old at the day of the election. Now, take a look at also dito yung qualification with regards to residency. A resident of the barangay for not less than 1 year immediately preceding the day of the election. So not on the day of the elections, but immediately preceding the day of the election. Now, dito sa membership, wala, silence siya. So meaning, a resident of the barangay for at least 6 months, so from that time na he's requesting for membership, dapat residente na siya ng barangay for at least 6 months. Also, at least 15 but not more than 30 years of age. So wala namang qualification. So it means that from the time you requested membership, you're already at least 15 years of age. Now, balik tayo dun sa ating... Okay. Okay. So, gaya nga ng sinasabi ko, the Secretary of the SK now is mandated to keep a list. And not only that, is also mandated to continuously update the list of members of the Katipunan ng Kabataan. Okay. Now, punta na tayo doon sa isang innovation pa ng SK Reform Law, yung anti-dynasty provision. Okay. Doon sa requirements ng pagiging appointive or elective officials ng Sangguniang Kabataan, there was a particular provision there. Tingnan natin, ha? Oops. Yan. It states that in order to qualify as a candidate and be voted upon as elective or appointed official of the SK, the person should not be related during the period of her candidacy and on the effective date of her election or appointment to within the second civil degree of consanguinity or affinity to any incumbent elected national official, nor to any incumbent elected regional, provincial, city, municipal, or barangay official in the locality where she seeks to be elected or will be appointed. Now, it states here, not related during the period of his or her candidacy. So, meaning, at the time he files his certificate of candidacy, dapat wala na siyang relasyon, okay, within the second civil degree of consanguinity or affinity. Kung sino-sino yung mga yon, yung sakop ng second civil degree of consanguinity or affinity, ipapakita natin mamaya yung diagram kung sino-sino mga yun. Pero tignan nyo it states here to any incumbent, okay, incumbent elected national official. So, ito yung isa sa mga gusto kong mapalitan para mas maganda sanang anti-dynasty law. Dapat hindi lang dapat elected official, dapat kasama rin yung appointed official because the ills or evils sought to be prevented, whether or not it is an incumbent elected official or appointed official, nandun pa rin. Okay? Now, yan. So, yung mga kasama doon sa second degree of consanguinity and affinity, in the IRR of Republic Act 10742, merong diagram. Okay, ito yung diagram. Teka lang. Wait lang hanap diagram. Yan. This is Annex A of Republic Act 10742. So, sino-sino yung kasama dun sa prohibition? Okay? Yung mother, father, son, daughter, that is the first degree affinity. Mother-in-law, father-in-law, that is the first degree consanguinity. Mother-in-law, father-in-law, first degree affinity. Brother, sister, grandfather, grandmother, grandson, granddaughter, second degree of consanguinity. Consanguinity means by blood. Okay? So, grandfather-in-law, grandmother-in-law, brother-in-law, sister-in-law, second degree affinity. Now, there is a problem with this. Why? Now, if you will look at the diagram of the Civil Service Commission, tignan nyo in the Civil Service Commission diagram, in the counting of whether or in a relationship, degrees of consanguinity and affinity, yung grandparents-in-law, brothers, sisters-in-law, and grandchild-in-law, nasa third degree siya. Okay? Great-grandparent, aunt, uncle, niece, nephew, great-grandchild, nasa third degree siya. Whereas, in Annex A of the SK Reform Law, yung grandfather, grandmother is in second degree of consanguinity. And the grandfather-in-law, grandmother-in-law, second degree of affinity. So there is somehow a conflict when it comes to the counting of degrees. Okay. I will have a separate lecture on this provision, the anti-dynasty provision of the SK Reform Act. So for the meantime, let's skip this. But that's one of the problems na nakita ko. There is a conflict between the counting with regards to the Civil Service Commission diagram and Annex A of the IRR of Republic Act 10740. Okay. Let's go now to another topic. Benefits. Question, is the SK scholarship under CHED Memorandum Circular number 15 series of 2009 include graduate studies? O, kasi di ba merong scholarship ang SK chairperson. Okay. Kasama ba doon ang graduate studies? My answer is yes. What is my legal basis? Okay. First, there is no qualification provided under the law. Secondly, the term tertiary education should be interpreted in accordance with the provision of the universal Universal Access to Quality Tertiary Education Act or Republic Act 10931, wherein it refers to the stage of education following the secondary cycle governing higher education programs and graduate education. So, kasama siya. Okay. Note, however, na ang libre lamang as provided under the CHED Memorandum Circular is tuition and matriculation fees. So, yung miscellaneous fees are not included. Now, entitlement of leave privileges and maternity benefits of the SK channel. Ngayon, kasi di ba yung age bracket na is from 15 years of age to 30 years old, di ba? So meron ng mga miyembro ng Sangguniang Kabataan na may asawa na, meron na ring anak. Now, either entitled to leave privileges and maternity benefits. Yes, reason. Under Article 203 of the Local Government Code, now Section 12 of RA 10740, which states that the SK chairman shall enjoy the same privileges as a regular Sangguniang Barangay members. Now, with regards to cumulation and commutation of leave credits, ito, limited lang. You know why? The reason is that barangay official does not have any fixed compensation. They receive honoraria. Okay? Now, under Memorandum Circular number 83-21, dated June 6, 1983, of then Ministry of Local Government, only those elected officials who are receiving regular salaries can request for the cumulation and commutation of leave credits. However, in a joint memorandum circular dated number 1, series of 2004, binigyan na ng limited na pwede nang i-commute yung leave credits nila. I think for the first year lang yata. Yun ngayon yung binigay lang. So, limited lang yung rights nila with regards to the cumulation and commutation of leave credits. It is expressed in Section 3.0 of the CSC DBM Joint Memorandum Circular number 1, series of 2004. Now, palaging tinatanong, can a barangay official, including SK official, free to exercise their profession? Okay. Sabi ng DILG Opinion number 88, series of 2010, dated June 9, 2010, as well as the Supreme Court in Cato versus Atty. Reliosa, AC number 5738, dated February 19, 2008, they can. However, those who are in the civil service, hindi pwede. Why? Because of the express provision regarding double compensation. Now, let's go to the term of office. Under Section 11, the term of office of a chairperson as well as the 7 Sangguniang Kabataan member is fixed at 3 years unless sooner revoked for cause, okay, or permanently incapacitated or resigned from office. Now, however, if you will look at Section 11 of the IRR, it specifically states in the second paragraph that any elected SK official who possesses all the qualifications and none of the disqualification is eligible for re-election. In the law is silent. Basta ang sabi lang, fixed 3 years term. In the IRR, merong dinagdag. Okay? Nakalagay, any elected SK official can be re-elected. Now, if you will look at yung pinakita natin kanina, yung repealing clause, di ba? Yung mga ni-repeal. Hindi ni-repeal yung provision ng Section 2, RA 9164. In fact, what was repealed was Section 1 and 2 of RA 9340, which amended Section 1 and Section 2 of RA 9164. Ano ba yung nakalagay doon sa Section 2 ng RA 9164? The second paragraph specifically states, no barangay elected officials shall serve for more than 3 consecutive terms in the same position. So when you say barangay elected officials, according to the Supreme Court as well as the local government code, kasama ang mga SK officials. So what does this mean? Ibig sabihin ba when the Republic Act 1740 repealed Section 1 and 2 of RA 934, did it revive Section 2 of RA 9164? Meaning, hindi na no barangay elected officials shall serve for more than 3 consecutive terms. Pwede na. O, since the law is silent, it means na hindi eligible ang SK for any re-election. My take on the matter is that by virtue of the repeal of RA 9340, even though nakalagay expressly in the IRR, because an implementing rules and regulation cannot amend, modify, restrict, or expand what is provided in the law itself. It only seeks to interpret the particular provisions. So the insertion of the paragraph, any elected SK official who possesses all the qualification, which gives SK officials the right for re-election, I think should be struck down because it is not contained in the original law. And because of the express repeal of Section 1 and 2 of Republic Act 9340, which revives Section 2 of RA 9164. But again, this is a contentious issue until the Supreme Court, in the case of first impression, will make a definitive decision on the matter. It's still in the gray area. So, under Section 17 of RA 10742, hindi na lang yung Sangguniang Kabataan chairperson ang considered person in authority. So, kasama na yung Sangguniang members. Okay? And there shall be considered persons in authority only within their jurisdictions. Suspension and removal from office. So, Section 18. Now, If you will read Section 18, suspension and removal from office. Again, this is also problematic. You know why? Because the ground for suspension as well the ground for dismissal is basically the same. Yung ground for suspension ay pareho dun sa ground for dismissal. So, however, in Section 16, there was an emphasis of due process. Maybe that's the saving grace. Maybe the reason behind this is that the gravity of the offense will be determined by the factual circumstances of the case. Now, ano yung mga grounds for suspension and removal? Teka lang pala. Nakalagay dito, any elective official of the Sangguniang Kabataan may. Okay? So, anong ibig sabihin nun? Ibig sabihin, pwede kang mag-file din ng administrative complaint elsewhere. So, walang exclusive jurisdiction yung SB o SP, Sangguniang Bayan, o Sangguniang Pambarangay. So, you can file an administrative case against the erring official with the Office of the Ombudsman, the DILG, etc. Okay, first paragraph. Absence from the regular meetings of the Sangguniang Kabataan without valid cause for 2 consecutive times. Okay? Or accumulated absences of 4. Sino yung sinasabing, kanino patungkol itong paragraph A na to? So, under Section 9, it should be the Sangguniang Kabataan, meaning the SK chairperson and the 7 members. Okay? Together with the treasurer and secretary, kasi dapat kasama sila palagi sa regular meeting. Paragraph B, failure to convene the regular assembly of the Katipunan ng Kabataan for 2 consecutive years. Kaninong function to? Under Section 6, should be done by the chairperson. Okay? So, once for every 6 months. So, hindi mo pwedeng kasuhan yung members of the SK kasi precisely, hindi naman sila yung naatasan na mag-convene ng regular assembly ng KK. C. Failure to convene the regular Sangguniang Kabataan meeting for 3 consecutive months. Okay. It's specifically provided the chairperson. D. Failure to formulate the comprehensive barangay youth development plan and the annual barangay youth investment plan or approve the annual budget. Sino-sino yung mga dito? The SK officials, meaning the chairperson, the members, the secretary, and the treasurer. Why? Secretary is mandated to post the CBYD as CBYDP as well as the ABYIP, the Annual Barangay Youth Investment Program, as well as the Comprehensive Barangay Youth Development Plan. And the treasurer, pwede rin siyang makasuhan under this provision because he is the person in charge for the disbursement of funds. Now, paragraph E, failure to implement programs and projects outlined in the Annual Barangay Youth Investment Program without justifiable reason. It's the chairperson who should be liable under this because under Section 13C, it is he who shall ensure the implementation of the policies, programs, and projects as contained in the ABIP, the Annual Barangay Youth Investment Program. Under paragraph F, 4 consecutive absences, sino? Chairperson specifically provided. And conviction by final judgment of a crime involving moral turpitude. Now, crime against moral turpitude, there is a decision from the Supreme Court wherein the issuance of bouncing checks can be considered as a conviction, can be considered as a crime involving moral turpitude. Now, please note that the grounds for suspensions and removal, sinabi ko na kanina, pareho. Please note also that paragraph A and F refers to consecutive absences. Now, note also that under paragraph B and C, okay, yan, paragraph B and C, unlike in paragraph A, in other paragraphs, may nakalagay without valid cause, di ba? Sa D, nakalagay without justifiable reasons. Now, bakit in B and C, walang nakalagay na valid cause, without valid cause, or without justifiable reason? What is the intention of the framers? Bakit inumit nila yan? Okay. Maybe because that's why they inserted yung phrase na after due process. So meaning, it will not bar the subject official from presenting in his defense na the failure to convene the regular assembly or the failure to convene the regular Sangguniang Kabataan meeting was due to an event which is outside of his control. So maybe that's the reason. That's why in section 18, there is too much emphasis on due process. Okay. Now, there was a decision of the Supreme Court in the case of Pablico versus Villapando. Sinasabi doon na wala daw karapatan ang Sangguniang Bayan o Sangguniang Panglungsod na mag-dismiss ng any barangay official. Now, the legal basis on the ruling of the Supreme Court is Section 60 of the Local Government Code because it states in the last paragraph that any elective local official may be removed from office on the grounds enumerated above only by order of the Crown. Now, ano na ngayon? May karapatan ang Sangguniang Bayan o Sangguniang Panglungsod na mag-suspend o mag-dismiss ng SK officials. So how will you reconcile that now? Okay. So we will use a statutory construction. Section 60 of the Local Government Code, although it was not expressly repealed by RA 10742, pertains to elective local officials in general. Okay. Wherein Section 18 refers only to SK officials. So my take on the matter is that the SB or the SP has the authority and jurisdiction to suspend or dismiss SK officials. Okay. However, mas naging problematic. Why? Because if you will read the IRR of Republic Act 10742, nakalagay doon, taking into consideration the local government code and other applicable laws. So, is this phrase now referring to the previously cited Section 60 of the local government code or to other provisions of the local government? But for me, I think by virtue of Section 18 and by virtue of the express provision giving authority to the SB and SP, they have jurisdiction to suspend erring SK officials. Okay? Anyway, meron naman doon nakalagay na caveat na the suspension should not be more than 6 months. Now, in 2019, there was a memorandum circular regarding the guidelines on the local youth development plan. So ito yung mga bagong innovations na nilagay doon sa. I will not belabor you in discussing all of this because to tell you frankly, napakadaming memorandum circular sa mga stakeholder agencies gaya ng National Youth Commission, the DILG. In fact, even the COA was asked to issue a circular with regards to financial disbursement. And I tried to incorporate it to the book, pero masyadong makapal siya. So, also, if you will notice later on, if you will purchase my book, at the end of the book, may mga appendices. Ito yung mga memorable circulars issued by several government agencies. Kasi masyadong maraming stakeholders. So, the memorandum circulars naman and administrative issuances with regards to the subject is very self-explanatory. So, you can read it. And if you will purchase the book, it is explained thoroughly naman in the book. Okay. So I will just skip this. Now, meron binuo, it is the Local Youth Development Council. So the composition of the LYDC as well as the Local Youth Development Office. In fact, the creation of this was mandated by the law. So, yung mga probinsya, they usually pass an ordinance for the creation of this office. Yung composition niya sa kayong qualifications, it is stated in the law itself. So, ito yung problematic lang dito sa Local Youth Development Office kasi 'di ba ang youth is from 15 to 30 years of age pero yung LYDOF officer yung qualification is preferably not more than 30 years of age. So meaning pwedeng lumampas. Okay. Now, let's go now to the Katarungang. Let's go now to the revised Katarungang Pambarangay law. Okay. So, the revised Katarungang Pambarangay law is can be seen from section 399 to 422 of the Local Government Code. Okay. Now, question as to the constitution of the Lupon. Okay. Most authors of the Katarungang Pambarangay law book opine that the first step in the constitution of the Lupon is the determination of the numerical limitation of the members. Kasi, di ba, merong numerical limitation doon. Now, ang tanong diyan is, during the incumbency of the punong barangay, as long as it is within the 50-30 numerical limitation, pwede niya bang dagdagan o bawasan? Okay. My answer is no. Why? because of the use of the word term and not tenure. So it's basically provided that the constitution of the Lupon, okay, will be at the beginning of the term of the punong barangay. So what's the reason behind this particular provision? Kasi it is because the chairman of the Lupon is also the punong barangay, and that the secretary of the Lupon is also the secretary of the barangay. So, para magkaroon ng continuity, it should be constituted at the beginning of the term and should be coterminous with the term of the punong barangay. Now, another question. Are government employees allowed to be appointed as members of the Lupon? So, elected officials, no. Why? Again, because of the provision in double compensation. Now, how about non-elected government officials? Yes, they can. Why? By express provision under Section 406. In fact, this has been decided by the Supreme Court in the case of Lorenzana versus Atty. Fajardo, AC number 5712, June 29, 2005, that a government employee can be appointed as member of the Lupon Tagapamayapa. Now, another contentious issue. Are the records of the barangay proceedings confidential? Because essentially, when there is conciliation or mediation, there is so-called laying of the cards. So nasabi mo na yung mga depensa mo, nasabi mo na yung mga ibang factual circumstances, even then evidentiary matters, di ba? But under Section 404 of the Local Government Code, the minutes as well as the documents presented during the mediation and conciliation proceedings are considered public records. Okay. In fact, some scholars believe that this is a violation of the right of an accused against self-incrimination. Okay. So, is it confidential? By virtue of the Section 9, by virtue of Section 9 and 10 of the Alternative Dispute Resolution Law, hindi na ho siya considered as public records. So confidential na siya by virtue of Section 9 and 10 of RA 9285. Now, actual residence doon sa jurisdiction ng barangay conciliation. What does it mean? In Beher versus Court of Appeals, GR number 7940 for January 27, 1989. Bago magkaroon ng conciliation at magkaroon ng jurisdiction yung particular na lupon taga-mapayapa ng barangay, okay? Yung actual residence na nakalagay doon means not just actual residence. Hindi lang yung nakatira yung isang partido doon sa barangay na yon. But sabi ng Supreme Court doon sa Beher, it must be coupled with actual membership. So ano yung tinatawag na actual membership? Yan yung diniscuss natin kanina doon sa SK, di ba? The barangay secretary is mandated under the law, under the Local Government Act, to list down the... So, dapat nakalista ka doon. Okay? At the same time, actual residence ka ng barangay. So, membership alone will not suffice. Actual residence alone will not suffice. So sabi ng Supreme Court, actual residence coupled with membership in the barangay. Now, complaints with provisional remedies. Under the Katarungang Pambarangay law, if a particular action in court is coupled by a provisional remedy, hindi na siya dadaan sa conciliation sa mediation proceedings sa barangay. However, in Rakpan versus Baroga, in Rakpan versus Baroga, sinabi ng Supreme Court na pag mayroong provisional remedy, hindi na dadaan sa mediation and conciliation proceedings. However, in Peregrina versus Judge Spanish, wherein a particular complainant filed for an application for preliminary attachment, hindi siya pinagbigyan ng korte at sinabmit pa rin yung kaso, binalik ulit doon sa barangay to undergo mediation and conciliation proceedings. Bakit anong pagkakaiba ng Rakpan sa Peregrina? In Rakpan, nung final yung kaso doon sa korte, meron na siyang nakalagay doon na application for preliminary injunction. Whereas in the Peregrina case, okay, sabi ng Supreme Court, yung application for preliminary attachment is just an afterthought. Bakit? Kasi sa kasong ito, okay, nung nag-file ng motion to dismiss yung kalaban, kasi nga yung complaint niya, premature, kasi walang nangyaring barangay conciliation, imbis na mag-file ng opposition yung complainant, nag-file siya ng application for preliminary attachment. Kasi alam niya na pag mayroong provisional remedy, baka hindi na dadaan at hindi na ibabalik sa conciliation and mediation proceedings under the revised Katarungang Pambarangay. But the Supreme Court said, hindi, sinircumvent mo yung batas and that the filing for a preliminary attachment is just a mere afterthought. Okay. Please note also that family dispute under Article 151 of the Family Code needs conciliation and mediation proceedings. Sa Article 151 ng Family Code, bago ka makapag-file ng kaso kasi, dapat doon sa iyong complaint na final sa korte, merong specific statement that the case, bago pumunta sa korte, it underwent earnest efforts for conciliation proceedings, yung mga family members. Kung sino-sino yung mga family members, that's stated under Article 150 of the Family Code. Now, the Katarungang Pambarangay is actually a three-tiered process. So, meron munang conciliation before the Dupon Chairman, which is the punong barangay. Then, pwedeng pumunta sa pangkat ng tagapagkasundo. And then, pwedeng magkaroon ng arbitration proceedings. So, it's a three-tiered process. Now, in Alinsugay versus Kagampang, yung respondent during the conciliation proceedings, hindi nagpakita. Okay. Question. Kailangan pa bang i-constitute yung pangkat ng tagapagkasundo? Sabi ng Supreme Court, hindi na. Kasi it will be an exercise of futility. Kasi hindi na nga nagpapakita despite notices yung respondent. Kasi kung i-constitute mo pa daw yung pangkat ng tagapagkasundo, wala ding mangyayari. Okay. However, in Ramos versus Court of Appeals, nag-iba ng tono ang Supreme Court. Sabi ng Supreme Court, kung hindi nagkasundo ang partido, kailangang i-constitute ang pangkat ng tagapagkasundo. So, what's the difference? In Alinsugay versus Tagampang, it is the respondent who fails to appear in the conciliation proceedings. Whereas, in the case of Ramos versus Court of Appeals, it is the complainant who fails to appear. Now, based on these two Supreme Court decisions, meron na tayong Rule 1 and Rule 2. Rule 1, kung yung respondent ang hindi nagpakita, pwede nang mag-issue yung lupon ng certificate to file action. Hindi na kailangan i-constitute yung pangkat ng tagapagkasundo. Now, Rule 2, pag yung complainant, yung mismong taong nag-file ng complaint ang hindi nagpakita, there is still a need to constitute yung pangkat ng tagapagkasundo. So meaning, hindi pa dapat mag-issue ng certificate to file action ng lupon. However, in the case of Bonifacio Law Office versus Bonsilio, regardless whether or not yung respondent ang hindi nagpakita o yung complainant ang hindi nagpakita, kung hindi pa tapos yung 15-day period, kasi binibigyan yung lupon chairman, hindi punong barangay, 15 days na pagkasunduin yung partido. So pag sabi ng Supreme Court sa Bonifacio, kung hindi pa na-exhaust yung 15-day period, kailangan pa rin i-constitute ang pangkat ng tagapagkasundo. So if the lupon shall issue the certificate to file action prior to the expiration of the 15-day period, ibabalik ng korte yung kaso for barangay conciliation. And it will be dismissed for prematurity and failure to comply with condition procedure. Now, ito rin minsan palagi ding nagiging issue sa mga lupon. Now, for example, si A at si B nag-away sa isang barangay. Si A pumunta na doon sa nag-file ng complaint sa barangay. Then after that, walang conciliation na nangyari, binigyan ngayon ng certificate to file action. Si A, with regards, for example, slight physical injuries. Kailangan pa bang kumuha din ng certificate to file action? Si B, hindi na. Okay? Kasi, pwede na niyang gamitin yung certificate to file action na in-annex ni A kasi ang kailangan mo lang namang i-prove sa korte, dumaan siya sa conciliation or mediation procedure. Now, question. For example, yung final mo na complaint doon sa barangay, is slight physical injury. Binigyan ka ng certificate to file action for slight physical injury. Ngayon, gusto mo nang mag-file ng ng another case, for example, threat. Kailangan mo pa bang ulit bumalik doon sa lupon at magpa-issue ng bagong certificate to file action? Kasi yung certificate to file action na binigay sa iyo para lang sa slight physical injury. The answer is no, hindi na kailangan. Why? Leyuwi versus George De Castro. Okay? When the issue is logically connected dun sa first case. Please disregard yung GR number. Hindi kompleto. Now, pag nagkaroon na ng kasunduan doon sa barangay, is the crime extinguished? Yes. Opinion number 100, series of 1979 of the Ministry of Justice. Okay. Ito rin, isa din sa mga debate, appearance and representation of lawyers in the enforcement of settlement and execution. So, in Section 415 of the Local Government Code, bawal po ang abogado na mag-represent sa conciliation and mediation proceedings doon sa barangay. Ngayon, kasi pag nagkaroon kayo ng kasunduan sa barangay, the kasunduan will be the subject of an execution proceedings. So pag nagkapirmahan kayo dun sa barangay, hindi ka na kailangang mag-file pa ng panibagong kaso pag hindi tumupad sa kasunduan ng isang partido. Although in some instances, later on, I will discuss this execution proceedings, pero pwede pa yan. But generally, ang gagawin noong isang partido, the aggrieved party, will file for a petition for enforcement of the barangay amicable settlement. Ang may jurisdiction ho yan is MTC, Municipal Trial Court. Okay. Tanong ulit, paano pag yung subject matter ng kasunduan nyo is 2 million, 3 million, which is outside the jurisdiction of the MTC? Pwede pa rin ba? Pwede. Pwede pa. Because it is the local government code who specifically states that the enforcement of barangay amicable settlement is within the exclusive jurisdiction of the MTC. You will not apply the ordinary jurisdiction of the MTC. Okay. So regardless of the amount. Ngayon, in the enforcement, halimbawa, nagkasundo nga kayo doon sa barangay, nag-file ka ngayon, pwede bang ang mag-file ng petition for enforcement of settlement and execution doon sa korte, abogado na? Diba? Well, under the old law, it seems na bawal. Kasi under PD 1508, the old Katarungang Pambarangay law, specifically states in Section 9, okay, in all other proceedings provided for herein. So, ibig sabihin, hindi lang siya limited sa proceedings doon sa barangay. So, under the old law, if you will file for an enforcement of a barangay amicable settlement, hindi pwede ang abogado. But look at now Section 415, the amendatory provision. It is state now in all Katarungang Pambarangay proceedings. So meaning, ang bawal lang na mag-appear ang isang abogado sa Katarungang Pambarangay proceedings. So yung execution, if the execution proceedings now is filed with the with the MTC, so hindi na siya sakop, pwede nang mag-appear ang abogado. Also, one of the reasons is that the local government code cannot limit or regulate the practice of law, which is only within the authority of the Supreme Court to regulate. Okay. Ano pa ba? Now, execution. Now, let us read Section 417. The amicable settlement or arbitration award may be enforced by execution by the lupon within 6 months from the date of the settlement. After the lapse of such time, the settlement may be enforced by action in the appropriate city or municipal court. Now, we summarize this. Okay. So, under the case of Chavez, pag hindi na-repudiate within 10 days, the aggrieved party has 2 remedies. The first remedy is under the local government code, the KP law. Okay? The second remedy is under the rules of court. Under the first remedy, the enforcing authority is the lupon chairman. While in the second remedy, the enforcing authority is the presiding judge of the MTC. Now, in the first remedy, what we will do is to file for a motion for execution doon sa lupon chairman doon sa barangay. While in the second remedy, you must file a petition to enforce barangay judgment. Okay. Period. With regards to the first remedy, should be enforced within 6 months from the date of settlement. In the second remedy, it can be enforced even after the 6-month period. In Vidal versus Escueta, it discussed the reckoning period of, it discussed where to reckon the 6-month period. Okay. Kasi di ba? Pag kaya saan mo i-recon yun pag yung obligation is conditional? Kasi, for example, in Vidal versus Escueta, this is a interesting case. Si A and B have an amicable settlement in the Katarungang Pambarangay law. It states that after 5 months, saka lang pwedeng umalis. After the 6-month periods, saka lang magiging obligasyon ni A na umalis doon sa kanyang tinitirhan. Pero maglalaps na yung 6-month period. So paano ngayon yan? Kasi the law specifically states that the 6-month period should be reckoned from the date of the agreement. Sabi ng Supreme Court, hindi. Kung strict implementation yan, kagalagay dun sa agreement mo, saka lang obligatory yung provision doon, stipulation yun, after the 6-month period. So, sabi ng Supreme Court, in this particular case, it should be reckoned from the time the obligation is already due in the month. Now, another, di ba merong dalawang remedy? Yung first remedy is salupon. The second remedy is petition to enforce barangay judgment mo sa korte. Now, question, pwede ka bang mag-resort ka agad dun sa second remedy without exhausting the first remedy? Okay? In the case of Promu versus Court of Appeals, sabi ng Supreme Court, pwede. Why? Liberal construction of the rules. But however, in Vidal versus Escueta, sabi ng Supreme Court, no. You must exhaust first the first remedy. Why? The reason ng Supreme Court, because the law was specifically designed to afford the parties during the 6-month period a less expensive, simple, and speedy enforcement of settlement. So dapat dito muna kayo. Kasi pag natapos na yung usapan, sa inexpensive process, kaysa pupunta ka dun sa korte, di ba? Mas maganda na i-exhaust muna yung first remedy. So, yung remedy ng agreed party, for example, hindi tumupad yung pumirma dun sa kasunduan sa Katarungang Pambarangay law. Ano yung remedyo niya? In Chavez, dalawa yung remedyo niya. Una is to enforce the compromise agreement under the first and second remedy as stated in the table. Or kung gusto naman niya, halimbawa, nagkasundo sila na, halimbawa, may utang na 100,000 pero base doon sa kasunduan, 50,000 na lang yung babayaran noong nagkakautang. Now, question, pwede bang bago ang isip nung isa. Halimbawa, hindi nagbigyan ko na nga, yung 100,000 na utang niya, 50,000 na lang ang babayaran, hindi pa niya nababayaran. Diba? Can A insist after non-compliance of B na hindi na, ayaw ko na i-enforce yung amicable settlement natin na 50,000. Doon na ako sa 100,000 ulit. Pwede ba yun? Yes, pwede. Under Chavez versus Court of Appeals. A can file a civil action and treat that the original agreement is already rescinded and insist on the original demand. Okay, that is the end of my presentations. Salamat po. If you have questions, you can message. Hello?
Thank you for that very rich presentation, Attorney Valera. We are very honored to receive such expert guidance, especially at a time when the study and practice of law have become more challenging. We are with you in your initiative to provide expert guidance in grassroots administration of justice. In behalf of Rex Education, allow me to congratulate you on yet another feather in your cap with the release of this book. We look forward to learning more from you through your books and lectures. Once again, congratulations, attorney, and here's to more years of working together as stewards of legal education.
Thank you.
All right. For those who haven't joined our online raffle, you still have a chance to be included on our live draw later. So just click on the link pinned in the comments section below. And also, you may ask questions to the speaker by typing them in the comments section. There will be time allotted for Q&A at the latter part of the session. And now we are very honored to be joined by another legal expert. Let us all give a warm welcome to USEC John Paulo V. Salvajan, Undersecretary in charge for the Office of Alternative Dispute Resolution, Department of Justice.
Good afternoon, everyone. Originally, I had been requested to provide the afterword in Attorney Aristotle Valera's book, Understanding the Katarungang Pambarangay Law, Notes and Cases. I was basically supposed to write on how the book came into existence, how the idea for its creation was formed, or react on any question or questions that may have been intentionally left unanswered in the book. However, due to very limited social interactions as brought about by the ongoing pandemic, I did not have the chance to be fully oriented on those objectives. While I was therefore able to compose the corresponding afterword, I felt apprehensive that it did not reflect the appropriate output required. My apprehension was a bit relieved when I was instead presented with this opportunity to deliver this testimonial for the author. Considering that I have known Attorney Aristotle Valera, or Attorney Aris as I usually call him, for quite some time already, I thought my task should become easier. But I was wrong. It was harder to make a befitting testament to Attorney Aris' character when he wrote the book, mainly because of my knowledge how enthusiastic he was with its creation. I hope that my few words now could do such dedication justice. Attorney Aris' level of dedication was similar to his law office's motto as found in their firm's webpage: passion for the profession, commitment to the craft. In my past interactions with Attorney Aris when I was still in private practice, I can attest that he stayed true to such phrase. Indeed, through the said book, Attorney Aris has shown passion and commitment towards his advocacy of having a simpler, more expedient and accessible way of delivering justice for all, especially to the less fortunate members of our society. As may be observed, although the barangay justice system is well entrenched within our legal system, much of our citizenry is unaware or unmindful of its full potential and beneficial impacts. While recourse thereto is made mandatory for covered disputes, it does not generally result in proper utilization by the disputing parties. there are those who perceive this alternative dispute resolution mechanism as mere condition precedent before resort to courts could be had, instead of treating it as genuine opportunity by which parties could peacefully resolve their disputes and emerge with a possible win-win situation. Through his book, Attorney Aris helps in addressing such abbreviated view. The scholarly discussions, which did away with needless pedantry, should lead readers not only towards academic comprehension, but also pragmatic appreciation of the societal benefits of the barangay justice system. The book helps obviate the view that resort to the barangay justice system is a mere mechanical exercise. These positive effects are made apparent because of the technical knowledge and practical legal experience selflessly poured in the book by Attorney Aris. As the Department of Justice's Undersecretary in charge of the Office for Alternative Dispute Resolution, or OADR, I sincerely commend Attorney Aris for this publication, which came in the midst of a nationwide health crisis. It is our shared view that importance should be given to the barangay justice system as well as the persons involved therein, such as the Lupong Tagapamayapa members, who should be recognized as frontline justice workers integral in accomplishing the law's laudable objective of delivering swift and true justice for everyone. After all, experience has proven true what the great Greek philosopher Aristotle, and incidentally the author's namesake, once said: "It is in justice that the ordering of society is centered." I therefore again wish to extend my sincerest commendation to you, Attorney Aris. Your level of passion and commitment has been immortalized through these publications, which will definitely constitute as one of your greatest legacies. May you also continue to embody the jurisprudence quoted on your law firm's webpage, which states that the lawyer's best advertisement is a well-merited reputation for professional capacity and fidelity to trust based on his character and conduct. Congratulations, Attorney Aris.
Thank you very much, Yusek Salvahan. We are very honored to have you grace this event and guide us through how the book can help and guide us achieve our dream of hurdling the law bar exams. And now, we are very honored to be joined by another legal expert who can best guide us on how we can use the book for an optimum learning, especially for the upcoming bar examinations. Let us all give a warm welcome to Judge Michael J. Tagare, Presiding Judge, Katipunan, Madela, 2nd MTCC, Quirino Province.
Congratulations, Attorney Aris Valera, to my good friend, for the launching of your two new books, Understanding the Katarungang Pambarangay Law and Understanding the Sangguniang Kabataan Reform Law. I was able to read it and it blew my mind, very updated. It's about time that we have a book regarding this up-to-date and easy-to-read kind of books regarding the Sangguniang Kabataan and the Katarungang Pambarangay Law. Highly recommend it to law students to...
At this point, let us hear more about how the works of Attorney Aristotle Valera plays a significant role in shaping our young lawyers, aspiring lawyers, and our public servants today. Let us all give a warm welcome to Professor Leon G. Flores, the 3rd CESE, former Undersecretary and National Youth Commission Chairperson, Ateneo School of Government.
Mabuhay! I am Leon Flores III, the former National Youth Commission Chairman and now a Professor of Praxis for the Ateneo School of Government. I would like to give my heartfelt congratulations to my good friend and longtime ally in the youth development sector. Dati Aksyon Kabataan pa kami, ngayon Aksyon Katabaan na ako. But we used to really volunteer and have been active in the youth development work since our Raul Rocco days. So Attorney Aristotle Valera, congratulations for the launch of your new book, Understanding the Sangguniang Kabataan Reform Law. So this is a very landmark and instrumental book because we feel that Sangguniang Kabataan, the SKs now, including all the different youth development experts, practitioners, a part of the ecosystem of youth development, should have this as their staple read because it helps us understand the nuances of the law and helps us also understand the historical information of how the SK reform was passed and how the SK has been through the years. So this is one helpful, very insightful book that can guide our SKs do a better job, and every SK should be able to read from this and learn from it to make them become more effective youth development practitioners in their own localities and communities. So we know that the SK, as I said in my foreword, the SK has been a beleaguered institution, always threatened by abolition, and the best way for this threat of abolition to be quelled or ceased or stopped is to make sure that our SKs now, this new batch and crop of SKs that have been elected because of the SK reform law, are more effective in carrying out their tasks and duties. And this can only be done if they prepare themselves thoroughly, and this book will definitely help them create more insightful programs, more effective programs, because it helps guide them how to go about their work and operationalize their vision for the respective communities. So with this, again, congratulations, Attorney Aristotle Valera, for this wonderful staple read. We look forward to more books from you, and this is really a great read for our SKs and youth experts. So please don't waste time and get yourselves a copy right now. So dagang salamat at mabuhay ka, Attorney Aristotle Valera, mabuhay ang Sangguniang Kabataan, mabuhay ang Kabataan Pilipino.
Hearing your praises of the book gives us utmost pride for having been chosen and entrusted with the publication of this masterpiece. In the same vein, allow us to express our gratitude to you as well for being stewards of legal education and of law practice yourselves. And now we're opening the floor for our question and answer portion with our author, Attorney Aristotle Valera. So feel free to comment your questions below. We will be selecting 3 questions from the comments. Once again, if you have questions for Attorney Valera, feel free to comment your questions on the comment section below. Do you have any questions from our viewers? Once again, we are opening the floor for the Q&A with our author, Attorney Aristotle Valera. So feel free to comment your questions below. We will be selecting 3 questions from the comments section. And also to those who haven't clicked on the link yet for our online raffle, please do just click on the link on the comments section for you to be included on our live draw later. Do you have any questions for Attorney Valera? All right, I believe we do not have any questions. Attorney, anything else you would like to say before we proceed to our online raffle?
Thank you very much for the opportunity. and to my students, thank you. Actually, these two books are the first and second volume of an Envision 4-volume Barangay Governance Encyclopedia. So what's up for the third and fourth installment? Siyempre sa Rex din.
All right, thank you, Attorney, and once again, congratulations. All right, this time, as promised, we will now be giving away a copy of these new books. Who will be the lucky one to win the books? Understanding the Sangguniang Kabataan Reform Law, Notes and Cases, and Understanding the Katarungang Pambarangay Law, Notes and Cases by our beloved Rex author, Attorney Aristotle Valera. Again, reminder, we will be announcing the name of the lucky person for this raffle. If your name is called, please do comment down present so we know you're here with us. We will then verify if it's you who won. However, if after 30 seconds we did not see any comment, we will be drawing another winner from our list of registrants. All right, so good luck. And we have a winner. Congratulations to Ms. Ana Potian. Ms. Ana, if you're here with us today, please do comment present on the comment section below and we will verify if it's you. We only have 30 seconds to comment present, Ms. Ana. All right, congratulations, Ms. Ana. Our Rex representative has seen your comment present. All right, once again, congratulations, Ms. Ana Putian. You just won the Understanding the Sangguniang Kabataan Reform Law, Notes and Cases. All right, so a Rex representative will be sending an email to you for the details on how to claim your prize. All right, let's go for our second winner, who will be the lucky winner to win the Understanding the Katarungang Pambarangay Law, Notes and Cases. And we have a winner. Congratulations to Miss Keska Tolentino. Miss Keska, if you're here with us today, kindly comment present on the comment section below so that we can verify that it's you. Once again, congratulations to Miss Keska Tolentino. We will be allotting 30 seconds for you, Miss Keska, to comment present on the comment section. All right, congratulations to Ms. Keska Tolentino, our Rex representative, has seen your comment. So congratulations, Ms. Keska. You just won a new book, Understanding the Katarungang Pambarangay Law, Notes and Cases by Attorney Valera. So once again, congratulations to our winners, Ms. Ana and Ms. Keska. A Rex representative will be sending you an email for the details on how to claim your prize. Once again, congratulations. On that note, we have come to the end of this afternoon's program. Indeed, it was a very productive learning afternoon with our legal luminaries, Attorney Aristotle Valera, and our distinguished guests from the field of law. In behalf of Rex Education, I would like to express our heartfelt gratitude for having been chosen as your partner in legal education. We look forward to more years of our fruitful partnership as we continue to work together to enable law students and lawyers achieve their dreams of becoming lawyers and excelling as one. To everyone who joined us this afternoon, thank you for learning with us and for choosing Rex to be your partner in learning. See you all on our next book launch and lecture. Thank you and keep soaring, Edu Campeones.